Yeah, I mean, the biggest thing is going to be to get over that.
Okay.
That's just going to be a challenge.
Start kicking it around. Not even talking.
Yes, sir.
What is there people living? Is there people overnight studies and stuff? Is that a different permit? What are you talking about? Same place. The dump spot.
First I'm here. That's a question for the complaint about that.
That's just how they start one thing and go into another, you know?
Yeah.
Anyway, well, I guess Trish is not here again. So hold off the duty thing because we didn't notify him. So did I.
Yeah, but he's going to put that.
Oh, yeah, I'm ready for him, so. But that's just discussion. Actually, first of all, we're gonna be covering the membership for 169 strong. I don't know what these two bills are, because in my homework here, these two bills are kind of like supporting towns that understand what we want to do. We're doing works and that. You can't just be a blanket and say every town has to do X, Y, Z. It doesn't work, because every town is different. Who cares what they say? But I was told from the higher ups, who cares what they say? I said, oh. Yeah, but this is still, it's still, it's for me, everything about it. So you're asking me about something I don't know much about. We're reading it, there's a lot of literature that came out, it's all fresh. Once I feel comfortable, we'll entertain it. So, let's push this along. I'm going to say, well, things are coming. I don't want to make a rash decision. I don't want to go in or against your favor. Right after the holidays, we'll revisit this when everybody's a little more knowledgeable. That's the way I feel. Everybody else can change. But it's not dead in the water, but it's something that I'd like to look into more. If I could. If I can't, then I can't. If that works.
Yeah, we got a guy in the camera.
You know, I turned it around so the audience can see it. But yeah, they should be interviewed.
Good evening. I'd like to call to order North Branford Planning and Zoning regular meeting for November 21st. Please remove your cap and join me in saluting the flag, please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. At this point, I'd like to introduce the members of the commission seated here tonight. To my right, my left, is Ron Cian, a regular member of the commission. To his left is Barry Ponder, a regular member of the commission, and to his far left is Paul Marino, an alternate member of the commission. To my right is Janet Crane, a recording secretary, and at the administrative table is David Perkins, our town planner. Finally, my name is Robert Nowak. I'm the chairman for the commission tonight. Paul will be seated as a regular member with all rights as a regular member. Before moving on, I'd like to entertain a motion to revise the agenda to add a new item to the agenda.
I move to add a new item to the agenda to withdraw the Planning and Zoning Commission's request of 2024-22 to amend any zoning regulations regarding poultry and lighting.
We have a motion, we have a second.
Second.
Motion by Paul, second by Barry. Any discussion to add the item? Okay. All in favor, say aye.
Aye.
Passes 4-0. New item on the agenda is the withdrawal of application. Moving on to item number 3 on the agenda. Withdrawal of application 2024-22, amendment to the zoning regs, amendment to section 41.2.11, lighting in sections 44.4.5.3 and 44.5.4 poultry and livestock. I'll entertain a motion to withdraw the application put forth by us.
I'll make the motion. I'll make the motion to withdraw.
Okay, we have a motion to withdraw, second by Ron. Discussion.
I think that the town has spoken. Right now, the lighting should be a pretty much a dead issue. The poultry, maybe we should look at it a little bit, but revisit this maybe springtime, summertime, for some sort of changes, but not as drastic as the state has put out there.
Okay.
Keeping in mind, all these changes came from the state, not from this board. Yeah.
Quick question,
Go for it.
can we override the state?
No. In my opinion, I don't think you can.
Well,
You can only have something more severe than what they propose, if I understand that correctly.
they're not state regulations, they're recommendations.
For the
So
light,
therefore we can't.
for the light. You could do whatever you want.
All right.
All in favor?
So we had started out with a regulation on the books that we, just to summarize in brief, we're here with the chickens as far as amending the regulation because we discovered that basically we had some complaints from some taxpayers about those who weren't caring for their chickens. And so we looked at the regulations and we went far left on our regulations that went too far requirements. So we had a public hearing, we listened to what the public had to say, and we revised our recommendations or guidelines based on what we took in from the public. So we did our job as a commission and we listened. We then proposed a revision to that actually was center right, where it's actually more than what our regulations currently have, where the regulations currently allow you to have 20, we proposed you can have 24. Abiding with the farming community that we are, we thought that was a good idea. Farming community should have more chickens. In addition to that, the setbacks were restricted for those on smaller properties because of the fact that based on the current regulations as written, puts your enclosure and your chicken coop in the middle of the yard. So we took the liberty to reduce the setbacks to make it more conducive to what was what everyone's doing in their backyards, where we went from 25 feet to 10 feet, made it more conducive for everybody. But neither here nor there, so we're gonna look at that. As far as the lighting goes, the lighting was, again, a state law that was put out for state buildings that we learned from testimony from the public that I don't think fits in this town at all, even though in some research and looking at it, 6 towns out of the 169 towns in Connecticut adopted some form of those guidelines. We're gonna step back to the lighting completely and revisit that again with more input from everybody for both items, so we'll take a different approach in 2025. So with that being said, any further discussion for the members? All in favor of withdrawing application 2022, amendment to zoning regulation amendment? All in favor, say aye.
Aye.
Aye, motion carries 4-0. Application is withdrawn. Next item on the agenda is number 4, renumbered. I'm sorry.
We do the minutes.
Oh, we did.
No, we should
No.
do the
No, we
minutes
didn't.
now.
Oh, okay, I'm sorry. You said item number 4, that's right.
Item number 4 is the minutes. The renumbered, since that was a previous number 3. New item added was number 3,
I'm confused.
to withdraw the application. So item number 4, the new item number 4 is the minutes.
Got it?
Right?
You've been in with that one, right?
No, leave this open. We'll allow these people.
Ask members to consider the approval for minutes from November 7th, 2024. Take a moment to review them if you haven't already. Let me know if you have any changes, amendments, or corrections. Then I'll entertain a motion to approve the minutes when you're ready.
I'm good. Before.
Did you like withdraw it twice?
Yeah, I just think if the withdrawal of the number 3 minutes become number 4.
Also, we need a motion to request to withdraw, then they talked about it next to the 4. It was like a double thing. Oh, okay.
Good.
Make a motion to approve the minutes from November 7th, 2024.
We have a motion, we have a second.
Second.
Motion by Barry, second by Ron, to approve minutes from November 7th. Any discussion? All in favor, say aye. Aye. Motion carries 4-0. Approval minutes from November 7th. Next item on the agenda is the new number 5, public hearing and public action. It's a public hearing for 3 items on the agenda. I'd like to go through a little narrative on how we're going to run the meeting. Purpose of the meeting is to hear all pertinent testimony of those in support of and in opposition to the application before the commission. Hearing will be open, testimony will be heard in the following order. Applicants explaining their application, project proposal, staff commissioners ask questions or comments on the application. General public have an opportunity to speak in support of and in opposition to the application in the form of statements or questions. Applicant have an opportunity to respond to the public comment and provide closing statements as necessary. Staff and commission will again have an opportunity to comment. When all sides have spoken, public hearing will be closed. No further public discussion will be entertained. After the public hearing is closed, the commission will vote on the application. Some of the rules for public testimony. When addressing the commission, please speak into the microphone. State your name and address for the record. All comments to be addressed to the commission, not the applicant. Be relevant to the application and should not be of a personal nature. Please limit your comments to 3 minutes. Once your time has expired, please be respectful of the commission and other members of the public who want to speak. Please avoid repetitive comments. Once public hearing is concluded, Out of respect for this body, we kindly ask that the audience take any discussion about the results outside the chamber so we may continue with our business. I always like to add a statement based on who we are as a commission. We all live in town and we decide to serve this community. We're not paid for our time. We come from various backgrounds and provide different perspective on every issue presented before the commission. The commission roles address land use in North Branford. The use of land is covered by the regulations and plan of conservation and development. We rely on experienced and qualified employees of the police department, fire department, our engineering and planning departments as well in town to ensure health and safety aspects are considered through their agency's point of views. We also rely on the town attorney to ensure we keep within the policy and procedure of the state's laws and town ordinances. Commission takes into consideration all points of view when we decipher the facts from hypotheticals, compare the facts against the regs, and decide what is in the best interest of all town residents of North Branford. We then render decision based on our common sense, logic, and reason, based on all factors noted above. Next item on the agenda is application 5A for the amendment for the zoning regs, which we have since withdrawn. That concludes any discussion on the zoning regs. Moving on to item 5B, application 2024-24, 79 Branford Road, R80. Before I ask the applicant to come up and discuss, I'd ask Commissioner Potter to read into the legal notice into the record.
Please insert the following legal ad in the Sound on Thursday, November 7, 2024, and Thursday, November 14, 2024. Legal notice. North Branford Planning and Zoning Commission. Notice is hereby given that the North Branford Planning and Zoning Commission will hold a public hearing at 6:30 p.m. on Thursday, November 21st, 2024, at the North Branford Town Hall, 909 Foxton Road, North Branford, Connecticut, to consider the following. A, applicant number 2024-24 special use permit, request under CSG 8-30G to allow for the current 3 residential buildings to be lawfully occupied with 1 unit to be designated as affordable housing at 79 Branford Road. Owner, Andrew Arabolis. Applicant, attorney Timothy Hurst. B, application number 2024-2025, zoning map amendment to change the parcels at 435 and 465 Foxton Road from R40 residential zone to B1 business zone. Applicants, John Casavetro and John Duty. At this hearing, all interested persons may appear and be heard and written communications will be received. Copies of proposals are on file for public inspection in the Town Hall Planning Department. Robert Nowak, Chairman.
Okay, applicant, would you come up and state your name and, sure.
You can sit down or you can sit.
Good evening, Mr. Chairman, members of the commission. For the record, my name is Timothy Herbst. I'm a partner at the law firm of Marino, Zabel, and Schellenberg, located in Orange, Connecticut. I'm here tonight on behalf of my client, who, as you noted in the reading of the public call for this meeting, is seeking a special use permit at 79 Branford Road, map 2D lot 11, pursuant to Connecticut General Statutes 8-30G, the Affordable Housing Land Use Appeals Procedure, to take 3 existing residential dwellings and to allow them to be lawfully occupied, with 1 unit being designated as affordable housing. Before I get into my presentation tonight concerning this proposal, I just want to state that I have been dealing with 8-30G for a very long time, but when I dealt with 8-30G, I was sitting on that side of the table when I was on the Trumbull Planning and Zoning Commission many years ago, and I had to deal with a lot of high-density zone busting applications, and as many of you know, that can present a challenge for localities to deal with. So this is the first time where I am on this side of the table presenting an 8-30G application, and I would not be here tonight proposing this 8-30G application if I did not feel that it was consistent with your overall goals, with your affordable housing plan, consistent with the statute, and allowed the town of North Branford to grow its affordable housing stock in a responsible way without zone-busting neighborhoods or changing the character of your residential neighborhoods. I want to state that from the onset. As you will note from the special use permit we filed in my transmittal letter of October 21st, 2024, this property is interesting and unique in that it has 3 pre-existing non-conforming structures that have in the past been used for residential purposes. And there is a history with this property in terms of zoning enforcement that I'm sure your staff report will reflect, where they were being used for residential purposes but out of compliance with the underlying zone. So we looked at this and we said, how do we deal with making these properties and these dwellings compliant, but at the same time doing it in a way that is a win-win not only for the applicant but also for the town. So the plan before you tonight would take, and I'm going to refer to the site plan, which I think you should have. So as you can tell from the site plan, there are 3 structures that come off of the road. There's already sewer lateral connections for those structures. So what we are proposing is that of the 3, 1 unit, there'll be 3 units, 1 unit will be designated affordable, consistent with the statute. 30% of an affordable housing development must meet affordable criteria, affordable guidelines. So we are designating it, one of those as affordable, and we're going to set aside 1 unit for 60% of area median income households. I should note that the area median income for North Branford is lower than the statewide median. This plan uses the lower figure. I also want to point out that the site plan delineates which will be market rate and which will be affordable. Now, consistent with the statute, we are required to proffer an affordability plan and how that affordability plan will be administered. That should be in your informational packets that you've received. So the plan talks about what units are going to be set aside, what unit, I should say, singular, is going to be set aside. It indicates that there's a 40-year period of designations. It talks about development sequence, talks about entities responsible for administration and compliance of affordable guidelines. It details the affirmative fair housing marketing plan. It gives provisions on eligibility requirements consistent with the statute. It delineates the application process for the affordable unit. It talks about the deed restrictions that would come into effect, and then it has a Schedule A that provides the definitions and elements of annual family income for purposes of determining that 1 unit and the affordable guidelines for that unit. We drafted, per the request of your town planner, a proposed regulation for your consideration. And we drafted a regulation that I think, obviously you do not need to use it as operative in your determination tonight, but we offered a proposed regulation just to share with the commission what we believe to be the appropriate uses and intent for an affordable housing regulation. You will note that we indicated that they should all have a single-family residential appearance. We talked about the purpose, which is to encourage the private sector to build moderate-cost, single-family detached housing, demonstrate that changes in zoning requirements can promote production of attractive housing at less than average market rates, offer a home ownership opportunity, permit an alternative housing option. And it says under the proposed regulation, uses permitted in the affordable housing district, only single-family detached houses. shall be permitted. So we put that in specifically to address and assuage any concerns that the commission might have or the public might have, that this, when people hear the term affordable housing, they get scared and they think that they're gonna be staring down the barrel of 60, 80, 100 units. That's not the case here. We have 3 existing structures. We're bringing them into compliance by proposing this application. It's pretty straightforward. We have designated on the site plan which one of those units would be affordable. We have an affordability plan consistent with the statute that demonstrates how this will be administered once approved, if approved, by the commission. And I should also point out that 8-30G presents a challenge for a lot of municipalities because you are required, like every other Connecticut municipality, to show that 10% of your housing stock is affordable. However, a lot of towns that are even more developed than North Branford have a challenge with meeting that 10% threshold because many of these towns are 90, 95% developed. And they go to the state and say, how are we gonna get to the 10% if we're so developed and we can't get to that number? So some communities look at creative solutions to get up to that 10% threshold. Some communities allow for example, in-law accessory apartments to be counted towards the town's affordable housing stock. Some towns, like in the situation that is before you tonight, look at an existing property of nonconformity and come up with a creative solution to make it conforming and to help the town reach its affordable housing goals. We think that this proposal is innovative. We think it's straightforward. We think it's non-invasive. We think it meets the goals of not only your POCD, but your affordable housing plan for the town of North Branford. We believe it is consistent with the Connecticut general statutes. And as the statutes call for, under 8-30G, with respect to burden of proof, there needs to be a demonstration in denying the application that the public health, safety, and general welfare of the public far outweigh the need for affordable housing. I do not believe that this application as presented poses any immediate or imminent threat to public health, safety, or general welfare. We're taking existing structures and we're making them now compliant. There is a need for affordable housing in the town of North Branford. That's irrefutable. And we are basically saying you have 3 residential structures. We want to make one of them affordable under the statute. We want to help you increase your affordable housing stock. We want to bring a non-compliant property into compliance. And we want a win-win for the town, for the applicant. So with that, Mr. Chairman, I will take any questions that you or any members of the commission might have.
You had stated that, how does it become non-compliant after the approval of the 830G? Did I misunderstand what you just said?
No, so what I was trying to say is the affordability plan is a requirement of the statute. We introduced the affordability plan with the special use permit that we filed. That affordability plan becomes part of the approval because that affordability plan is required by the statute. And that is to guarantee compliance on a go-forward basis. And the affordability plan talks about, for example, as I mentioned, 40-year deed restrictions. It requires administration on an annual basis. There are parameters for how the unit is not only maintained its affordable status, but how you receive applications for the affordable unit and the objective criteria that has to be used. That is all part of this approval and is all part of this record and something that your zoning staff and your town will be able to refer to make sure that, presuming you approve this tonight, that we're not revisiting this a year from now or 2 years from now. It's all here, it's in front of you, we have a blueprint, and it's a blueprint that we can follow and make sure that there's compliance on a go-forward basis.
So 2 years from now, you are non-compliant with your own plan. What repercussions does the town of North Branford have with people living in unit number 4 as affordable housing? And if you guys fall out of compliance of your own plan?
If that were to happen, and I'm going to make sure that it doesn't, but if it does, if I'm still representing him, I'm going to make sure that it doesn't, but if it does, the town would then have on file and on record basically approvals that show what must be done, and the town would be able to take the necessary enforcement action to bring it into compliance.
Okay. All right. Tim, can you identify what the zoning regs, what part of the package is that? that you suggested to us?
The suggested regulation?
Yes, sir.
It's in the app.
Basically, what I did was, I drafted it as a proposed regulation, but I wanted to leave it to your staff and to you to determine where in the regulations you wanted to insert it.
Okay.
In terms of the numbering. But I wanted to give you language to work off of. You might say, Tim, we like all of it. You might say, Tim, we like none of it. Tim, we like some of it. But I wanted to put it in front of the board, just so you had a template to work with. I used language from other towns that I represent or have represented that have an affordable housing regulation. I know that this is obviously in a town like North Branford, which is growing. You see this emerging more in towns that are showing growth, and you obviously want to do it the right way, because as I often say, when you start wrong, you end wrong. So I wanted to put something in front of you, the bones of which I felt you would be comfortable with here in North Branford. And then if you want to tweak it in any way, I certainly will leave that up to you, but I thought it was a good baseline to start with.
Again, Tim, what page was that? Because I know they're numbered in your packet, right? Oh, it's not numbered? Schedule A, there's different things in here, sorry.
It's a separate item. Do you have an extra copy of it?
I have an extra in my binder, I can give it to you.
And so
Part of the application requirement for the 830G is that there be a proposed zoning regulation submitted with the application. Nowhere in the process is there any requirement that the town actually use that zoning regulation or incorporate it into your zoning regulations. I think the only reason why an 830G application would be presented to you would be that they need to alter some portion of the zoning regulations. If they don't need to alter any portion of the zoning regulations, they just apply to you as a conforming use, right? And you would approve it because it's a conforming use. Right. Under the 830G, it assumes that there is some sort of zoning problem. Typically, it's density. So they want to build 100 units per acre where they can only build 40 units per acre. So in this application, the regulation is that you can only have one dwelling unit per lot. In this case, he wants to have 3 dwelling units on a lot. That's the only zoning regulation that you're actually in violation of, correct?
Correct, and that we're seeking to vary with this application.
Yeah, I'm not sure if we want to use the word vary,
No.
but the exception to the rule would be that he can have 3 dwelling units because the 3rd unit represents more than 30% of the dwelling units on the property, and therefore it complies with the 830G regulations saying that at least 30% of the units have to be deed restricted. Does that make sense?
So my understanding is that the plot plan has 4 buildings on it right now. 1 is a dwelling unit, or 2. How many is a dwelling unit out of the 4?
The 4th is an accessory building.
Correct.
There are 3 dwelling units, an accessory building.
Okay.
So to go back into the history of this, which was that there were many zoning violations on this property over the years, and that 3rd unit had been occupied, and cease and desist orders were issued, and it did get to Superior Court, and the judge issued an order that that unit could not be lived in. Subsequently, it was reconstituted as a residential unit again, and the owners were told to cease and desist, which they did. And now we have a relatively new owner of this property who came and applied for building permits to upgrade the third residential unit. And he was met with resistance by the zoning enforcement officer and the building officials saying, no, you can't occupy that building. So that's when Attorney Herbst came and applied for the 830G application to make that third unit legitimate under the 830G application.
So the owner was already in violation to begin with when he bought it, with having 2 dwelling units per the regulation, you're only supposed to have 1?
No, the two were non-conforming pre-existing
Okay,
structures.
gotcha.
Are these, the first two, the unit 1 and 2, is that two single-family houses? One single family, one single family?
Yes.
And the third building is another single family?
Yes.
That's what you want to do?
Yes. That is correct.
So is the owner currently the one that went to court and lost?
No,
No.
So the owner currently bought the property and is trying to change that third unit into compliance and can't unless he uses this card, this 830 card?
exactly.
So the third unit per our town is not legit, we'll say, for layman's terms, unless he comes out with this 830 request.
The underlying zone would not allow it. That's why
Correct.
we're before you with the 8-30. And essentially what we're trying to do, for lack of a better term, we're trying to clean this up.
And then you got setbacks are like 13 feet. Is that a setback, a 13-foot setback?
Again, they're pre-existing non-conforming structures.
And so what were they? They were garages or something?
It was a barn originally. Unit 3 was a
It
barn.
was an animal house, and now we want to turn it into a dwelling, a home,
Correct.
with a 13-foot setback. What's next to it? What's behind that 13-foot setback? What's back there? Is there a house next to it? Is it a?
No,
What is it?
it's vacant.
The other thing I wanted to just bring up, and I could have my client come up to speak to this, but one of the things that we noticed when we were doing our due diligence is obviously you check the tax assessor's office and the tax records to determine how the property is being classified for purposes of taxation. And I think that's relevant to this conversation. Would you like to just share with the commission what we discussed about how taxation is?
It's being taxed right now.
Excuse me, hold on, could you state your name? and-
I'm
Andrew
sorry.
Arbolis, 30 Youngs Apple Orchard Road, Northford, Connecticut.
Thank you.
The property has always been a house. It's been a 3-bedroom, 2-bathroom house for as long as I can remember. We bought the property a little over 2 years ago, and since then, we've fixed up the 2 houses in the front, new siding, windows, doors, roof, everything's brand new. We went to the back one, we started to do the same thing, we put a new roof on it, pulled all the proper permits, new siding, and that's when we came to a little bit of pushback from the town when we tried to pull a permit to do the interior and turn it into a dwelling. Currently, we're being taxed on it as a residence, but we cannot use it as a residence.
So that's, again, that goes to why we're trying to clean this up.
How would they tax it if it's, as a residence if it's not?
There's a file about 1 inch and 3 inches thick that's in the town hall here with legal proceedings and things that have gone back and forth with this residence for 30 years. The previous owner, I guess, illegally built it as an apartment and was renting it to various people.
He said it was a barn.
I don't know if it ever was a barn. It's
Now I'm confused.
yeah, it's in the original documents as a barn. At some point, they turned it into a house. It's a 39 by 60-foot structure, single-story ranch.
Anything else you'd like to add, Dave?
No. think Attorney Herbst may address the affordability aspect of the application in terms of what the rents are like relative to the market rate rents, just for information.
So I think I briefly touched on that when I was going through the affordability plan. As I mentioned, there's a 40-year deed restriction on the affordability component. And then we talk about eligibility, so that's section 7 of the affordability plan. It says eligibility of families or households to rent an affordable unit at the property shall be determined by the administrator, which was defined earlier in the plan, in accordance with Congen Stat 8-30G as amended. And then it says subparagraph A, 60% of median income units, households whose income is less than or equal to 60% of the area median income or 60% of the state median income, whichever is less, as determined by the U.S. Department of Housing and Urban Development, shall be eligible to lease the affordable unit designated for 60% median income. And then it gets into the application process for how that would
So
happen.
just if I can at that point, the 60% median income for a single person is $48,762 a year. And they can't pay more than 30% of their income in rent. So the rents are about $1,200 a month. So it's not cheap.
How much is it? 1,200 a month?
For a single family, for one person,
For the affordable unit.
under the affordability
That
statute.
48,000, is that for a North Branford resident, or is that the state median?
That's the Meriden, the local area.
The local, because the plan calls for the lower of the two.
Is that our area or is that an area?
That, you said Meriden.
It includes
the
Meriden
south.
and New Haven and North Branford. It's a region.
Okay.
It's a
In
regional
this
figure
area.
because the regional figure is lower than the statewide. And the affordability plan talks about going with the lower of the two.
What was the number again? 48,000?
48,762, that's for a single person.
What about a family?
I
No.
didn't even get into family, but obviously it's gonna be higher.
Okay.
Any other questions?
No.
Good.
There's only one driveway, right, for the 3 buildings currently?
Correct.
That one, okay.
Can the fire marshal say something about that?
The fire marshal's comments got back to the property owner and the attorney?
I don't think I gave it to you.
Town engineer I received, not fire marshal.
Okay.
Want to read it, Mary?
Yeah, I can read it. This is a memorandum, wrote to Dave Perkins, the town planner,
Thank you, sir.
from Bert Burnell, fire marshal. Owner occupant must follow all CGIP, Connecticut General Statutes, NFPA, Connecticut State Fire Safety and Fire Protection Code. Our concern is the driveway distance and width to the building 3 to get apparatus and ambulance there in the event of a fire safety medical issue. It seems the width from inner driveway to property line is 20 feet. No dimensions given on driveway width. Also gravel driveway construction going to be compacted to handle fire department apparatus. This office would like to stress the importance of minimizing fire load conditions when possible and keeping combustibles away from heat source objects at your facility. It is the owner's responsibility to inspect and maintain full compliance with all fire safety code requirements.
Thank you, Barry.
No problem.
So I think his concern was that the driveway be widened to the fire marshal's wishes, as well as compacted so it can handle apparatus.
They look like they got plenty of room on the property to widen it. It looks like it's probably like 12 to 13 feet currently.
Right.
Probably needed to be like 18 to 20. I don't know what I think 20. 20 feet.
We don't see any issue with that, and then if the commission wants to make that a condition of approval, we would not be adverse to that.
Thanks, Tim.
Thank you very much.
I'd like to open it up to the public for those in support of this application. Would anyone like to speak in support of this application? Anyone like to speak in support of?
Hi, Kara Papa, 65 Great Hill Road, North Branford. I'm speaking in support of this application because there is a group meeting in town that is concerned about affordable housing coming in, and we're speaking from all viewpoints. We spoke about this property yesterday and that we are all in support of it. It works with all of our plans, like the attorney said. And so I highly support it. We should be opening this up so more of the non-conforming properties in town can also benefit from this, because it benefits us to meet our 10% also, as the attorney said. And I also want to point out for anybody who's concerned, our base teacher salary here for a starting out teacher is $52,000 a year. So we would also be opening up properties to support people to live in town that also work here. Thanks.
Thank you. Would anyone else like to speak in favor of the project? Anyone else like to speak in favor of?
Caleb Papa, 65 Great Hill Road. I support this because as a freshman in high school, I can see that this would really impact the town and the people who live here, especially the people working here.
Can I have your first name?
Caleb, Kaileb.
Thanks.
Anyone else like to speak in favor of? In favor of? Okay, anyone like to speak in opposition to the project? Opposition to the project? Anyone? Anyone like to speak in opposition to? Hearing none, then I'll entertain a motion to close the public hearing, unless you guys have any comments, questions. I gotta back up that step. Questions, comments? No? Dave?
Yeah.
Okay. Tim, a closing statement on your part? You good, or you wanna?
All set.
Okay. All right, then I entertain a motion to close the public hearing on this, item 2024-24, affordable housing for 79 Branford Road.
Make a motion to close the public hearing.
Okay. We have a second?
I'll second.
Okay. Motion second, any discussion? Hearing none, all in favor say aye.
All right.
Aye. Public hearing is closed. Okay. What's the commission's take on the application in front of us?
I think 830G is a bully.
I'm sorry?
830G is a bully. I don't care for it at all. The property was purchased for probably an investment, which is a good idea. The last property in the house in the back was non-conforming, it's too close. It is what it is. Should fit. You can't just pull out an 830 card and call it a day. It's a bully on the playground. That's the way I feel.
we need more time to just review this a little bit more and come back and,
Yeah.
I'd like to a little more time.
okay, digest it a little bit more?
My question is, maybe a big, in the big scheme of things, if I have a house that's affordable housing, and using the numbers, I have to rent it for $1,200 a month, which is dirt cheap. I can get approval on the house for affordable housing and then evict the people that are there in 12 months and put it back on the market for rent at whatever the market will bear at the time.
It's 40 years deed restricted.
So he's locked in. There's no changes to, based on the agreement he set forth in front of us, that he's supposed to monitor, the owner's supposed to monitor and everything else, as far as I understand it.
40
So-
years.
40 years, regardless if he sells it or not, still that deed goes with it,
Yeah, they put it up on page,
right?
You know, who monitors that?
Who
The
monitors?
the state will monitor it.
The state. Okay.
What percentage of our goal is this property? One? One out of, does it even add up to one? What percentage is it?
What's our percentage now of
What
affordable?
is this, how much does this property increase our percentage?
Minimally. We're at like 2% right now.
So how about we continue this till
to get the
till
full,
December? All right with you guys? Want some more time to look it over?
yeah.
Well,
Yes, sir.
what more information would you need from me?
Actually, just the whole package unto itself. And I think just to get our arms around the 830G and where we stand with it. He did propose the zoning regulations that's his. That's not part of the package.
Yeah.
Okay, that's my
Right.
fault, sorry.
Yeah, so that's not part of our package, number one. Number two, I think the commission would like a little bit more time to look it over. This is the first time for us, and this, a little bit of a challenge for us to get our arms around it. And come to more or less, come to terms with it is probably more appropriate.
Okay.
Fair enough.
Any information that I can give you or that you want to bounce off of me, I'm here to help you.
Maybe when he comes back, if he brings some photos, just to show what it looks like and what it's gonna be, and what it is. The possible photos, like a little board or what you guys got going on?
Public hearing is closed, so I don't know if I can do that. I think that would have to come from staff.
For next meeting, maybe? Put it out there, a little remnant. No?
I don't know how that affects what he wants to do, because he's in the process of, he made mention that he had a building permit, and he's renovating the unit, so
Is it done,
the
is the
first two.
permit's closed for building, he's like all set? His permit's done?
No,
So maybe we could see that
Right.
permit that he's putting in, the permit has a remnant with it?
I don't know, but I don't think that's part of it's not a site plan to review, it's
Yeah.
deciding what the property is going to do in the future, now and moving forward
Okay,
as an affordable housing complex. The whole development, all three of the four buildings is gonna be part of this whole deed restricted application that he put in front of us. He already renovated, according to the applicant, already
Two fronts,
renovated the
right?
first two in the front. So I'm sure they're gonna mirror one another, but that's neither here nor there for this conversation, okay? So,
Good.
next meeting, we'll have, between now and the next meeting, any questions or comments, direct to Dave for further information so we can move this forward, okay? Fair enough? Go ahead.
fair enough. And as Attorney Herbst said, the public hearing's closed, so
That's right,
I can give you information, but he can't.
right. Fair enough. Okay. So with that being said, we'll continue this application until next meeting. Thank you, Tim.
Thank you, Mr. Chairman.
Next item on the agenda is item 5C, application 2024-25, zoning map amendment 435 and 465 Foxen Road. The applicant has, here, rephrase that. Public hearing's open on this item, so the applicant's not present, but we did receive some correspondence, if you want to read it into the record, relative to this application.
I don't have it either. What's this one?
But just, okay,
The top one.
just this one?
Yes.
Yes, sir.
Okay. Alright. Alright, this looks like a letter from, Kurt Westfall, regarding objection to zoning amendment, Castrovitro and Duty, CE file number 2024.083. Greetings, we are North Branford citizens residing within 500 feet of the properties which are the subject of the above referenced application for zoning map amendment 435 and 465 Foxen Road. We ask that this objection be read into the record at the zoning commission meeting on Thursday, November 21st, 2024. We hereby object to the amendment for the following reason. Section 63.2 of our town code entitled Posting of Notice of Public Hearing Sign requires the petitioner to notify all property owners within 500 feet of the proposed zone change via letter, not less than 15 days prior to any public hearing. In our case, the attached letter demonstrates that this notice was mailed to us on November 13th, just 8 days prior to the hearing. This procedural violation requires the application be denied. The failure to provide the statutory required notice has deprived all homeowners with the right to object the zoning change, a constitutional due process violation. Neighboring properties owners closer to the subject properties received no notice of the hearing. The owners of 520, 524, 534 received no notice at all. The applicant's submission filed on October 23rd, 2024, Section 1 requires a complete and comprehensive statement of the reasons for any proposed change, including any special interest the applicants may have in such change. There is no statement on the application. North Branford's plan for conservation and development in the subject R1 zone includes the town's 2 principal schools. The proposed amendment fits squarely between those 2 schools in an area where parents drop their children off and where school buses line up for drop-offs 2 and 3 days every weekday. It is an area frequented by children walking, playing, bicycling. A business zone is antithetical to our town school zone. Finally, while the 2 properties at issue have been running businesses that have been grandfathered into our R1 zone, they are limited to the current operation and have the ability to obtain variances for their businesses. The change to a B1 zone would give these properties unlimited expansion to the vast array of uses permitted in a B1 zone, including a hotel. The families in North Branford have a distinct need and indeed a right to maintain their town's plan for conservation and development in the school zone. If the applicants have need or desire to expand their existing businesses, they may apply for variances. Thank you. Signed, D. Kurt Westfall.
Thank you, Barry. Since the applicant is not here present, we open the public hearing we read into the record, but we can't entertain any public comment, and therefore we're gonna continue this, and also because of the fact that it was not within the 14 days, we're gonna continue this public hearing until December 12th, at the next meeting. 12th?
Could I,
Well,
12th, December 12th.
like second.
Yeah, not the first, but the second.
There's our only one, yeah.
Yeah, we only have one.
Dave, can we put out, as it stands now, there's no application for anything to be built or anything
Correct.
constructed?
There's no site plan.
No, there's zero. So this-
Zero.
This fallacy about a hotel.
There's zero site plan.
It's just somebody stirring up the pot, we'll say. As far as work, there's nothing at your office, right?
Okay.
Okay. Thus concludes our public hearing. Item number 6, old business. No old business. Item number 7, new business. Application 2024-27, 49 Caputo Road. Site plan review. That did not pass in the wetlands and lack of town council approval. This agenda item is also going to be continued, and the applicant's not here. This will be continued until next meeting of December 12th, correct? And Dave, you'll pass on our comments relative to the fact that there's no rendering or any color scheme relative to that, please.
Yes.
Okay, thank you. Next item on the agenda is, under new business, CSG Section 824 referral regarding disposition of certain town-owned properties, 1599 Foxen Road, 127 Old Post Road, 53 Nina Drive, 627 Tutucket Road, and 293 Sea Hill Road. Dave, this item again is, by state law, required that the commission at least review it, just similar to what we do for the budget, right?
Correct.
They give us a budget, say, here, check it out, and if you like it, don't like it, make a comment, and then submit it to the town council. As Barry, as part of the blueprint committee, we've looked at these properties in detail, have we not?
We have,
And we all agreed at that meeting that it finally got proposed, and the town council is looking to sell the properties.
yep.
Obviously noted is, ours is just a referral, based on the submission by the town council. We take note that 1599 Foxen Road is dear and dear to our heart as far as what we wanted to propose for a site plan development. And I think we're working towards trying to do some regulations to kind of gauge that property more towards what, at some point in time, North Branford District will look like, if I remember correctly. With that being said, does the commissioners have any questions or comments relative to this referral?
No.
Okay. With that being said, I'll entertain a motion to accept the referral for town disposition of certain town-owned properties.
You want to just list the properties while we're here?
Sure. Versus what's in the motion, because the motion carries them, no?
Fine.
Okay. Yeah, I should have did that, I apologize.
I'll read it. I make a motion that the Planning and Zoning Commission report favorably on the Connecticut General Statute, Section 8-24 referral from Town Council regarding the proposed disposition of the certain town-owned properties at 1599 Foxen Road, Old Town Hall site, 6 acres developable. 127 Old Post Road, wet lot foreclosure, 0.4 acres, probably not buildable. 53 Nita Drive, wet lot foreclosure, 3 acres, probably not buildable. 672 Tutucket Road, buildable lot, bought by town for $95,000 and $2,000. 293 Sea Hill Road, 0.31 acres, probably a buildable lot. The plan of conservation development on page 57 proposes that the town determine appropriate uses for underutilized town-owned properties. It also states that the town should conduct a developer RFP for town-owned properties, including the Old Town Hall site 1599 and any town facilities that are located to the town center site.
We have a motion, we have a second.
Second.
Motion by Barry, second by Paul, for the disposition of 824 road properties. All in favor, any discussion? All in favor, say aye.
Aye.
Motion carries 4-0 for the disposition of town properties. Next item on the agenda, adoption of the 2025 meeting schedule. Any questions or concerns from the commission?
None.
So Ron, which days can't you make it because you're going to some other country?
There's quite a few.
That's what I thought. So, if there's no questions on this particular item for a meeting schedule, I guess I'll accept the motion to approve them as noted.
I'll make a motion to approve them.
Okay, we have a motion, we have a second?
Second.
Okay, motion by Paul, second by Barry, all in favor, say aye. I should say, any discussion? No discussion, we're good? Unless it conflicts with your vacation schedule.
I was trying to figure out when our Christmas gala is going to be held.
Okay. December 11th?
In 2024 or 2025?
Both.
Which year you referring to?
Well, I know 2024 is still in the planning stages.
That's what I thought, all right. All in favor, say aye.
Aye.
Motion carries that we approve the 2025 calendar schedule for next year already. Item 8, other business. Item 9, town planners report.
We'll have an application for the pavilion at the community center, Stanley Williams, at our next meeting.
Okay,
Okay.
And there's a subdivision application on the Totoket Road that's half in Branford and half in North Branford that we'll hear in January.
Where's that, on Totucket?
On Totoket Road at the top of the hill. They're basically two driveways that are in North Branford and all the lots are in Branford.
okay. That's interesting,
Yes,
to say the least. So we approve the driveways?
right.
Okay, literally. And so we have, a high school also, and 830G to talk about. And duty, so all those come back,
Correct.
okay. That'll be quite a busy meeting. With that being said, anything else, Dave?
No,
You're good? Gentlemen, anything else?
Nope.
Item number 10, adjournment. I believe this is Ron's item?
Do we need a site plan for our Christmas gala festivities?
You gotta submit an application, you know.
Can we use the water
I
company?
missed the date.
Can we use the water company of Vermillion?
Well, that's right. We could
We'll get the pavilion.
Yeah, the pavilion.
That being said,
Educational.
it's been fun. I got a cup of coffee at home with my name on it. I motion we adjourn.
All in favor, say aye.
Aye.
Motion carries 4-0. We're adjourned. 7:39.